Okay, now, even more stentorian. Okay, I am honored now to introduce our panel of respondents to Justice Landau's presentation. And I would like each of you to stand as I introduce you. Okay? So you know who's who. Okay. First of all, we have Stephen K. Green, who is the Fred H. Paulus Professor of Law and Associated and Affiliated Professor of History and Religious Studies at Willamette University, where he teaches courses in constitutional law, First Amendment, legal history, jurisprudence, and education law at the College of Law, and legal history and American religious history in the College of Arts and Sciences. Stephen Green. Okay, next is Norman Williams, who is the Ken and Claudia Peterson Professor of Law. He joined the Willamette Law faculty in 2001. Williams teaches Constitutional Law 1, Constitutional Law 2, Election Law, and a seminar on the U.S. Supreme Court. In addition, Williams also serves as the director of the Willamette Center for Constitutional Government. Okay. Finally, Professor Robin Maril is an assistant professor teaching constitutional law. Maril joins our faculty from the Human Rights Campaign. Applause? Okay. Where she served as the associate legal director for the past 5 years. Okay. Each of our respondents will comment upon Justice Landau's presentation, after which Justice Landau will have the concluding comment. Then we will open it up to your questions, which may be directed to any one of our 4 honored guests. Thank you.
Well, good morning. I'll go first because we're doing age before beauty, and I'm probably the oldest one up here. Let me begin by just saying that I've known Jack for 25 years, so it's hard to, anyway. Let me just begin by saying actually what a privilege it is, not only to be here, I love this group, I've spoken before it many times, but also what a privilege it is for you to have Justice Landau. Justice Landau really is Justice Landau really is a statewide treasure. I mean, he is. He's a man of significant public service, but his breadth of knowledge and wisdom, and as you heard, his wit, he really just commands so much gravitas. And he's been such a privilege to get to know, but also just his contribution to public discourse and the law in this state just is hard to overemphasize. And so, well, there's a lot to cover, and I think what we're going to do is we're each going to give kind of an initial observation, but not each of us take a 15-minute block, and then we'll maybe have more of a kind of a round table type thing. So there's a lot of things to cover. I guess the part I really enjoyed, I'm a historian as well as a lawyer. One of the parts I really enjoyed, and I thought Jack did a really excellent job on, is kind of just demonstrating, giving the background for the history of the importance of the 14th Amendment and what had come. And I cannot make any assumptions in my classes, and I'm sure my colleagues can't either, about our students' historical knowledge many times. And I often have students say, do I have to know this history? It might be a question on this history on the exam. But it's foundational. And one of the things I say to them is, okay, we have been not a nation, but basically with English settlement occurring about 420 years ago in Jamestown. Okay. Quickly after that, in 1619, we had the importation of the first enslaved peoples from Dutch ships landing in Jamestown. Okay. So for that long period of time, really up until as Justice Landau mentioned, it's not so much the 14th Amendment, it's actually the Civil Rights Acts, where we finally saw the demolition of, at least legally, separate but equal, racial discrimination. And many people in here are as old as I am. I tell my students, I can still remember coming back. I was raised as a small child in Australia. But my family, my mother's side of the family is from the deep southeast part of Texas, which is the piney woods and was part of the old Confederacy. So I remember as a 6-year-old child coming back, and my grandfather owned a Esso, Exxon gas station. And I remember going down there with my father really early on. I tell this story, my students hate me continuing to go on. Anyway, I tell this story. And we were standing there, and I remember noticing, this is not embellished, I remember noticing that my grandfather's gas station had 3 restrooms. It had a men's restroom, a woman's restroom, and a colored restroom. And the colored restroom, my grandfather never cleaned. It was stinky, awful. And I said to my father, kind of like, I'm confused. Why are there 3 restrooms? And my father's kind of, keep it quiet. Said, that's for blacks. And the naivete of a 6-year-old was, you mean black women and black men have to use the same restroom? I tell that story because that was within my lifetime. I'm getting old, but that's in my lifetime. And try to portray to my students how recent, if you think about 420 years of, English civilization in the United States, that's within the last 60 years since the Civil Rights Act, that at least legally we have said discrimination is no longer valid. That's the importance of the 14th Amendment. Okay. I want to get back to citizenship clause and due process, but I'll pass it off at this moment.
Thank you for that, Steve. That is, it's overwhelming sometimes to think. What I want to really focus on, at least in this brief moment, is to echo the importance of the 14th Amendment in this shift in our country, where we recognize, I think for the first time, that states weren't always going to protect their people. And I think that's one of the most sort of structurally interesting things teaching Con Law 1, is that the structure of the Constitution was, for the first 100 years, supposed to be this bulwark between individual rights and the tyranny of the federal government. And that what people really needed to be worried about was not that their state was going to step on their toes or infringe their free speech, but that the federal government was. And what the 14th Amendment really recognizes is that sometimes the state government is going to fail their people. Sometimes the state government is not going to look out for the individual rights of their people. And you see this because slavery was incorporated and baked into the Constitution that was drafted. That it was, we don't need to worry about the states, we need to protect these people. And I think that that is a huge shift, and the creation of this uniform constitutional baseline of liberty that you carry with you because you are in America, not because you are in Massachusetts or California or Oregon, but because you are in America, that this is the baseline for what we think people should have. And I think I do want to get into this sort of expanded idea of what liberty is and has become under the Due Process Clause. Because again, I think it reflects this acknowledgement of the need for federal protection of individual rights. And Justice Landau, you talked about, or Your Excellency, you talked about, respecting, but you talked about Griswold, right? And you talked about this sort of journey that we have been on as a nation of defining and understanding what it means to actually have our liberty protected under the 14th Amendment. And I think importantly, although, as you sort of wrapped up, that we do have this arc toward justice, and what I really love is the 1923 Myers v. Nebraska case, actually, that for the first time really expanded this understanding that we had of our liberty interest as protected, that liberty was not just the right to not be detained, which again, if you think of 1789 and people's understanding of liberty, interestingly, it was also reputation. I love that. The founders were very concerned about protecting reputation as a liberty interest. But so reputation, but being detained. And what we see in this shift of our modern sort of era of constitutional law and 14th Amendment is this idea that liberty is actually what you need to move through the world as a free person and to pursue happiness. And that is how we get Griswold and Obergefell and Lawrence v. Texas and Loving v. Virginia, that it is actually this expanded understanding. But as we've discussed, nothing seems to be settled. And so it does leave to us this question, and I think back to this idea of the 14th Amendment as a protection from the states. What happens when we sort of pull back and we say, well, separation of powers means we have to let the states step on your toes, right? Which is what you see in the Dobbs case of Justice Kavanaugh says, we are actually being scrupulously neutral in this decision. States have to have the right to discriminate, to ban abortion, right? It is also in Obergefell, the same idea of this is actually promoting tyranny because it is stepping on these states' rights. And I think what we learned from Brown is that there is a moment where we have to say we have a constitutional liberty basis and we're not going to go forward. And what I was remembering when you were talking about Brown was that Justice Rehnquist, when he was a law clerk in 1952, drafted a memo to, I believe it was Justice Jackson, is that correct? Where he argued that Plessy should be upheld, that the Supreme Court should not rule in favor of Brown because the court has no role in this moral back and forth, and this is a liberal issue. And I think we can't forget sort of the generational power that still sort of persists. So that's it.
Thank you for inviting me, and it's always a treat to hear Justice Landau speak. And it's also a special treat for me especially to call him a colleague here at the law school. It was a great loss for the Oregon Supreme Court when Justice Landau decided that he was going to enjoy retirement and enjoy spending time with law students and law professors rather than with his colleagues on the bench. So what was the Oregon Supreme Court's loss was Willamette University's College of Law's gain. Thank you, Jack, for joining us. It was a real treat to listen to Justice Landau's presentation, with which I entirely agree. And in fact, the 2 points that I want to make is that maybe Justice Landau was underselling the importance of the 14th Amendment to our constitutional development in history, or at least not fully bringing out its importance. And the first thing, and by the way, I'm happy to, as all 3 of us are, as con law professors at the law school teaching the 14th Amendment, we're happy to talk about individual cases and kind of doctrinal moves. And as Justice Landau notes, there are literally hundreds of U.S. Supreme Court cases alone on the 14th Amendment. So we could spend a year talking about each of them. But the first kind of atmospheric point, which is not about the doctrine, but is about its importance in our constitutional history, and basically that it took us from a confederation of quasi-sovereign states into a nation of one. And that was a transformative move, because the Constitution of 1787, as written and conceived by the framers of the original Constitution, was that we were going to be a confederation of sovereign states. Think the United Nations today. That there would be this national government, but that ultimately the more important government would be the individual states. That it would be the states that dealt with various issues. It would be the states that would protect your individual liberties. And in fact, as Justice Landau referenced in this famous pre-Civil War case, Barron versus the City of Baltimore, when the Supreme Court says the Bill of Rights doesn't apply to the states, part of the thinking there is, well, it's up to each individual state to decide what their individual rights are. Each state constitution can have its own Declaration of Rights, identifying for the people of that state what rights they have. And by the way, notice the Oregon Constitution of 1857, Article 1 doesn't describe the state legislature as Article 1 of the U.S. Constitution does with respect to Congress. Article 1 is our Declaration of Rights. Oregon began with rights before thinking about how do you structure the state government. The 14th Amendment entirely upends that conception of the United States of America. We're no longer a confederation of quasi-sovereign states. We're a nation. We just fought for preservation of the Union in the Civil War, but more importantly, we should think of ourselves as Americans first and Oregonians second. And it's the 14th, and today when I talk with my law students, that's just understood, that we're Americans first, Oregonians second. In fact, some of my law students will point out, well, I'm not from Oregon, so I'm not an Oregonian. I'm like, okay, good for you. Yeah. But that conceptual transformation of what it meant to be the United States of America is codified and reflected in the 14th Amendment. And you see that in the very first clause, the citizenship clause, which is a direct response to Dred Scott versus Sanford, guaranteeing citizenship. But there's another point in there that Justice Landau briefly referenced that I want to highlight for all of you. Prior to that, there wasn't even really a notion of citizenship of the United States. Citizenship was just citizenship. And Congress regulated citizenship. By the way, prior to the Civil War, you could freely immigrate to the United States. Congress did not restrict immigration. Some states tried to do so on health grounds, having inspections for immigrants as they were coming off the boats. But the whole pre-Civil War notion of immigration and naturalization was people are free to come here, and we're just going to regulate under what terms they can become citizens, period, meaning citizens of their state, meaning having the right to vote in their states. And it wasn't, by the way, until the 1880s that Congress passes an immigration law banning or restricting immigration, and it's one of the most virulently racist laws in American history, the Chinese Exclusion Act, banning individuals from China from immigrating to the United States. That was the first federal immigration law. So for a century, we made no effort to try to restrict immigration. And the 14th Amendment imposes limitations on those, on Congress's ability to regulate regulate citizenship. That we can talk about that, the birthright citizenship case. But it also, the Citizenship Clause, by recognizing this idea of being a citizen of the United States, again, reflects that notion that we're a nation, not just a league of quasi-sovereign states like the U.S. would be with respect to the United Nations. The second kind of other point, I guess I'd want to say is amendments are difficult things to talk about. And we still argue over the 14th Amendment process. And to give you a very recent example, the Equal Rights Amendment, guaranteeing equality for women, that was proposed in the 1970s. Congress proposed it and put a 7-year limit on ratification. Unfortunately for Congress, that coincided with when the U.S. Supreme Court was using the Equal Protection Clause of the 14th Amendment to start to stamp out gender discrimination. And so a lot of the impetus for passage of the ERA all of a sudden start to dwindle because even proponents of gender equality said, well, we don't really need to pass this. The U.S. Supreme Court is using the Equal Protection Clause to get rid of a lot of gender discrimination. And so there's a real laborious struggle to try to get ratification. Congress sees there's having a problem there, so they then pass another law saying we'll give states another 3 years. So we'll give them 10 years total. And at the end of the 10 years, we still hadn't reached the 38 states necessary to ratify the Equal Rights Amendment. Now fast forward to 2021. The ERA, we think, is dead. But all of a sudden, states which had previously not ratified the ERA or had even voted against ratification in the 1970s start saying, no, you know what, we're switching our vote. We're now going to ratify it. So as of today, we've hit the 38 states for ratification of the ERA. But the question is, well, does that 10-year time limit matter? And the fight about the 10-year time limit goes back to the 14th Amendment's ratification process of to what extent can states change their minds? To what legal effect should we be giving states that change their minds? And all I'll say is that those of us who focus on constitutional ratification processes find this a very difficult question. None of us want to call into question the 14th Amendment's validity, but if Oregon could, if we're going to allow states to change their mind about the ERA, why didn't Congress let Oregon and the southern states change their mind about the 14th Amendment? And so there's some real difficult questions that the ratification process of the 14th Amendment still raises for us today. Thank you again, Justice Landau.
Well, thank you. I'm really touched by the kind remarks. I really do appreciate it, and I've been teaching at Willamette for 34 years. Now? Boy, this is really sensitive. Okay. I've been teaching at Willamette for 34 years, and it's really been a wonderful association. I have learned so much, much from my friends and colleagues, and I just really appreciate the opportunity that I've had to be associated with Willamette and with these wonderful people. A couple of things came to mind as I listened to your responses. One, Norman, you're absolutely right in emphasizing something I didn't, and that is the transformative nature of the 14th Amendment in moving us from that collection of sovereign states to a nation. And I think that's absolutely right. But as somebody who teaches state constitutional law, I think there's even more to it than that. And that is, it is a nation now where it was more of a confederation before. People used to talk about these United States before the Civil War. Now we talk about the United States. At the same time, states do retain some sovereignty and in the spaces left by the federal government. The states must always be subject to the supremacy of federal law, but there's still a lot of wiggle room in there for the states. And there's opportunities there for the states, in particular in these times, to defend rights against the encroachment by the federal government. And so, for example, you see immediately after the Dobbs decision, you see states putting measures on their ballots to amend their state constitutions to recognize a right to abortion, where the Supreme Court says the federal Constitution no longer guarantees it. There are opportunities for states in there to still protect individual rights, to still act as those laboratories of democracy, even though we are, in a very real sense now, a single nation and no longer a confederacy. Robin, in response to your point, again, I absolutely agree. It's so important to recognize the significance of the 14th Amendment and its ability to protect not just the Bill of Rights, but also unenumerated rights, like privacy. And this is an area of great debate and controversy among judges and legal scholars. It's one thing to say, well, we can incorporate or not the Second Amendment or the Fourth Amendment. It's another thing to talk about rights that you can't really nail down in the text of the Constitution, and what's the scope of the court's authority to recognize those rights. And there are some, Justice Clarence Thomas, for example, would say, he actually would say that we should overrule Slaughterhouse, and that we would have the opportunity to incorporate the Bill of Rights against the states. But as far as additional rights are concerned, he has a very, very narrow vision of what those would be, limited only to those rights that would have been recognized in 1868 and nothing else. There are others who say, well, it's more of an evolving tradition. And then there are people in between who say, well, it's a matter of history and tradition. That's the test that the court purported to apply in the Dobbs decision itself. So it's an area of great debate, but it's also an area of just profound importance. We need to settle on what that is so that we can predictably define the scope of individual rights beyond just what's explicitly mentioned in the Constitution. Something that I just touched on, but certainly deserved a whole lot more attention, as Robin said.
Well, Justice Landau, actually, how much more time do we have for comments before questions?
It's about half past right now, so another 5 minutes.
Okay, real quick. He just actually raised the elephant in the room. And the elephant in the room, which all of us are dealing with, and I'm a historian, so I deal with it a lot, is what we've seen, this shift with the more conservative Supreme Court, when it's wanting to go back and then identify or at least discuss these unenumerated rights, that they are being very, very restrictive on what that means, and they've developed what we call the history and traditions test or the historical understandings test. And it's a form of what we call originalism. They want to go back and basically say, well, how broadly did the founders think about this concept of a right or this privilege? And my gosh, if they didn't talk about it or whatever, then it can't be a right. And so that's why we saw in Dobbs, reversing Roe versus Wade, I just finished a book where I discussed some of this, a very insincere opinion by Justice Alito, who basically says, well, look, we're going to go back to this concept of liberty, but we're not going to go back to the concept of liberty that's thought at the founding. We'll do it at the time of the 14th Amendment to determine whether they would have thought of abortion as a liberty interest. My first question is, well, why? Why? Because when they talked about liberty in the 14th Amendment, they were also relying on the concept of liberty that we saw in the Fifth Amendment, okay? So it wasn't like they were inventing a new concept of liberty. They were just restating it. But then also, this drives me crazy as a historian, this history and traditions test allows you to cherry pick, allows you to be selective in what history you did, okay? The first law that actually placed any restrictions on abortion was in Mississippi in the 1830s. But then it really wasn't until after the 14th Amendment when you saw a greater movement to place greater restrictions on abortion. And even at that point in time, still it was for the first possibly half of a pregnancy. Prior to quickening, women still had a right to have an abortion, or at least it wasn't outlawed. And Justice Alito just kind of ignores all that. And he basically says, well, as a result of my view of what the history and traditions are at this point in time, we don't have a protected right. So very selective. This is where the court is going. And I concur very much with Justice Landau. We need to start relying, I think, more and more on our state constitutional protections, because we do have a Supreme Court today that seems to be abandoning expansive view of many protections that are out there, both in the Bill of Rights and the unenumerated rights.
Well, and I would love to pick up on that. Specifically, when you employ an 1868 framework, and it's this question of, and Justice Sotomayor brings this up in her dissent of Dobbs, that, well, the drafters of the 14th Amendment in 1868 did not consider abortion to be something that was protected as a liberty interest. And what Justice Sotomayor says, they also did not see women as full, legal, equal citizens and humans, right? So this question, and I feel like that really begs two questions, really. One, what were the drafters thinking? And can we take that necessarily extremely seriously as now a country that does recognize the full legal status of women? But two, and something that I've just been recently percolating on, is has our understanding of liberty and rights truly evolved, or have the people that have had the opportunity to come to the table and interpret it evolved, right? We don't actually know what everyone thought about things in 1789 or 1868. In 1789, we know what wealthy landowning men thought, right? That's great. Have we evolved? Or is it just that more people are at the table sharing their thoughts and being allowed into the conversation? And I think that is really important.
All right, so to inject then, I guess, some debate into this and to show that we can disagree up here, I want to say something on behalf of those wealthy landowners of 1787 and say something in defense of history and tradition. I fully agree with my colleague Steve that the current Supreme Court are bad historians. They cherry pick their history. They selectively quote from the Federalist Papers, the papers written by Alexander Hamilton and James Madison explaining what the Constitution means. And they deploy different history and traditions tests. In the Second Amendment, if there's no law restricting firearms in 1791, well, therefore, you can't have that type of law today. But when it comes to reproductive freedom, it's the exact opposite, right? Which is, oh, we're going to read into the fact that maybe one state somewhere had some partial restriction on abortion. We're going to condemn the notion that there's any reproductive freedom whatsoever. So they are biased, bad historians. But I do want to say, as someone who very much agrees with Justice Landau's take on where American constitutional law properly interpreted stands, history and tradition defends a lot of these decisions. Brown versus Board was not, as some of the commentators at the time argued, a unhistorical or ahistorical decision. It was a proper reflection of what the framers of the 14th Amendment thought. And for those kind of conservatives who say, oh, history and tradition points us to a conservative minimalist reading of the Constitution, I say, go read your Federalist Papers. Alexander Hamilton did not take a minimalist view of individual liberty. James Madison did not take a minimalist view of individual liberty. The framers of our Constitution had a very expansive conception of what liberty meant. And the current Supreme Court evades that by, again, being selective. But I would not say that just because the current court are bad historians that we should therefore reject the value and role of history in constitutional interpretation. As a colleague of mine at Yale Law School, Akhil Amar, has written about extensively, if you actually take history seriously, you're going to find that there's a lot in there that has been supporting the U.S. Supreme Court decisions over the past few decades, taking an expansive conception of human rights.
Okay, I guess Justice Landau, you have the last word there.
Okay. Well, I don't want to turn this into a critique of the United States Supreme Court. I've never been on the United States Supreme Court, and I tend to try to withhold criticism until I've walked a mile in another person's shoes. That way, if they don't like the criticism, you're a mile away, and you've got their shoes. But I have to agree, I couldn't agree more wholeheartedly with the court's practice of selectively picking these sources. But in addition to that, I would add it's selectively applying its history and tradition test, because only in some circumstances is history the basis for its decisions. If you look at Trump versus United States, for example, in which the Supreme Court recognized immunity for the president from criminal liability for acts that are taken in the scope of his constitutional authority, you will search in vain in the majority's opinion for any discussion of the text or the history. It's actually the dissenters that talk about the text and the history, and yet in Dobbs, the court invokes history, although interestingly in Dobbs itself there's some inconsistency, because on the one hand the court applies this history and tradition test from Glucksberg, but it never talks about whether history and tradition required that test in the first place. But then it goes ahead and applies that test. And the examples are many, and my concern as somebody who spent 30 years on the bench trying to cultivate among the public and my students some respect for courts and the rule of law is that sort of decision making undercuts the credibility of the Supreme Court, undercuts the legitimacy of its decisions, and is a threat to all of us.
Okay, thank you once again. And again, in your Q&A, you may address any one of the four speakers here. A lot of juicy ideas out there. I'm looking forward to the questions. Thank you.
Hello, Justice Landau. My name is Mark, and I really thank you for your presentation, and I especially thank you for the last bit you gave on the executive order for birthright citizenship. I didn't realize that was the basis that they were using to make this judgment. And so my reflection and my question to you is, we've been throwing undocumented aliens into jail in this country for decades, for a very long time. Our jails are full of a significant percentage of people that aren't citizens. We've put our jurisdiction on these people forever, and now all of a sudden they're not subject to our jurisdiction. How does that work?
At the risk of trying to put myself into the head of administration lawyers, I think the argument is that there is a meaning of subject to the jurisdiction of the United States for some purposes, that is the 14th Amendment, and there's a different meaning of subject to the jurisdiction of the United States for other purposes. Reading the briefs in these cases, that seems to be the position that they're taking, that clearly these folks are subject to the jurisdiction in some sense, just not in the 14th Amendment sense.
Thank you all. I'm Nili. I know. It was a wonderful, informative, just brain-blowing discussion. Would you say that we're moving away from a federalist to a state rights kind of movement, just like with the right for abortion? And this, to me, has like a good side and a bad side. The good side is that states can protect rights that the government, this current administration, is trying to take away. But with regard specifically to the rights of women, would they be able to bring up that amendment and say, or that interpretation, and say, well, the state can decide or override the amendment by having, I think it's a certain, like 2/3 of the states decide that those rights are not guaranteed by the Constitution, instead of Congress, right? It's an option. It's Congress can decide or the states can decide. Can the states vote to take that away?
You want to take that?
Thank you, Nili, for that question. Great to see you again. I guess 2 quick points. First, and the less important, is I don't want to give this current Supreme Court a pass that it's a states' rights-oriented court. And I guess unlike Justice Landau, I feel free in criticizing the current Supreme Court, even though I'm never going to be there. They warrant the criticism that they get. And there are plenty of instances in which the current Supreme Court and the conservative majority are happy to trample upon states' rights. Gun regulation, right? It's just one prominent example. Forbidding Colorado and other states from preventing then candidate Trump from appearing on the ballot because of his participation in the January 6th insurrection. So again, the current conservative majority, when they only invoke states' rights when it seems to be a state's policies with which they agree. The second thing, I guess, the more important point is, and this goes to what Justice Landau said about the role of state Bill of Rights, is that the current majority does seem to be taking a view of a more minimal vision of the Bill of Rights, restricting the individual rights that we have under the Bill of Rights. That still sets a floor below which states can't go, but to Justice Landau's point and kind of addressing your question of that really does put more pressure upon individual states to start taking their state's Bill of Rights more seriously and to be thinking about, okay, well, if the U.S. Supreme Court's going to narrowly interpret the Fourth Amendment or narrowly interpret the free speech clause, well, then maybe the Oregon Supreme Court interpreting similar provisions in the Oregon Declaration of Rights should take a more expansive conception of those rights. That's no solace to Californians, but it at least allows us in states with a robust Declaration of Rights and a judiciary willing to enforce those rights, to have individual rights and a respect for them.
Actually, can I just add a technical point? Constitutional amendments can originate in states. So it's not just Congress has to be the ones to write to propose constitutional amendments. If it's hard to get the Congress to agree on a new constitutional amendment, it's going to be so much harder to get a supermajority of the state legislatures to propose a constitutional amendment.
Okay. Hi, I'm Lisa. And regarding birthright citizenship and, the challenge to it, I was wondering how many of, children who were born to foreign parents were the parents here legally in the past? And do you think we need a more clear and comprehensive path to citizenship?
I think the citizenship clause in the 14th Amendment, I think it's actually pretty clear. And at least the Supreme Court in the 1880s, 1890s, whenever it was, saw it as being pretty clear, right? And they certainly were not limiting it to just the children of former slaves who had not had citizenship by virtue of the Dred Scott decision. So to me, this is not much ado about nothing. It's much ado about a lot. But it's more of a political cudgel than I think anything. It's frightening. My daughter was born in China, and she is a naturalized citizen. And for the last year, I've been making sure she carries her driver's license with her everywhere. We have more proof of her being a U.S. citizen than I have of myself being a U.S. citizen. But still, what's going on today is more of a political move. I think the Constitution is pretty clear.
Hi, I'm Bonnie. This has been great. What I'm definitely hearing is not just the substantive issues, but also the way they're thinking and making decisions, the Supreme Court today. And I'm wondering, do you think this is a bunch of more rogue individuals, or do we have a bigger problem where Yale and Harvard are teaching this other way of thinking about it?
Okay. So I think that for folks interested in this, following the development of originalism as a sort of interpretation that was created in the it's not always been the case that we look directly to the founders in such a restricted way. And I think what is super interesting is that the Reagan administration the early Reagan administration tried to incorporate all sorts of interpretations and policies. And there's a clear record where people are saying, well, if we just leave this here in the executive realm, it's going to take us forever to make these social policy changes and make these big changes to the economy. What we need to do is incorporate this judicial movement. And so I would encourage folks to look into the advent of originalism as a dominating factor on the Supreme Court. And honestly, yes, it is in law schools, but I think that it is not necessarily law school's fault, and I'm not just saying that because I teach at a law school. I think that it is definitely a strategic, non-organic movement to restrict thinking. And I would encourage folks to look into that, but I'm going to pass it.
I think it's the last answer.
Well, but it's not the last answer, and I definitely don't want that here. No? Unchallenged.
We have time for 2 more questions.
Go ahead.
Hi, my name is Lucy, and I'm hearing wavelengths about the women's right to vote being in jeopardy. Is that related to anything you know about?
I haven't heard that, and my answer would be the same I gave about the citizenship clause. Have you heard about it? Okay. It's in the Constitution, you know?
Okay, so what this is, I just looked at this 2 days ago too, because I was like, huh? So what this is, it is the SAVE Act, which has passed the House. And what this would do would require extra documentation to prove citizenship. And the problem is there's a limited list of documents that are okay to prove citizenship to register to vote. And these include a birth certificate or an unexpired passport. The issue is that a lot of people don't have passports. Like my parents don't have passports because they don't travel internationally. I'm from Oklahoma. And they're not going anywhere. I mean, when you're already in heaven, I tell you what. So a lot of people don't have passports across the board. And the problem is that specifically married women who have changed their name, their birth certificate has their maiden name, and so they would have no way to prove that they are a U.S. citizen. So it would disproportionately impact women, and especially women in places like my home city of Oklahoma that have changed their name and aren't going anywhere and don't have a passport. So it's also sort of an economic issue as well. It does pass. I don't think it's going to go anywhere in the Senate, but it shows that they don't care if women vote, which.
Hi, my name's Frances, and the question I have is regarding the enforcement section. So if a state decides to pass something like that protects immigrants, how do they enforce it when the federal government decides that they want to use ICE to take people away anyway?
Well, generally, the power for immigration naturalization is seen to be plenary in Congress. And so states are generally not authorized to interfere with the Congress's or the executive's power with respect to immigration naturalization policies. We're encountering this, I think, with the argument over sanctuary cities. You can't force cities to be participatory, but cities cannot stand in the way of federal immigration enforcement.
Okay, I have one last question, which I'm going to, I think of it as one of the $35 questions. And that is, Article 3 of the 14th Amendment, as you know, makes it illegal for any person who participated in an insurrection against the United States government to ever serve in any elective office again. And it also provided that the only way to overrule this would be by a 2/3 majority of a joint session of Congress, or a joint session of whatever political body is in question, whether it's state or federal. So my question today is it possible to enforce Article 3 of the 14th Amendment retroactively?
Be careful what you wish for, then you're going to have President Vance.
So the Trump Colorado decision, the U.S. Supreme Court unanimously, surprisingly to me, held that Section 3 was solely for Congress to implement. And so Congress has to pass a statute deciding what qualifies as an insurrection for disqualifying an individual to serve as president. And given our highly partisan, polarized time, That's unlikely. A lot of us think, by the way, that decision was erroneous. There is a lot of history of where individual states had disqualified individuals from running for state legislature or for Congress, and that had been accepted. So why is it now all of a sudden that Section 3 can only be enforced by Congress rather than by individual states, or for that matter, the court? Right, the U.S. Supreme Court ducked the question as to whether then candidate Trump was an insurrectionist or not, and so this is one of several examples, in my opinion, of where the U.S. Supreme Court interprets a constitutional provision that just basically wipes it out of existence, which an earlier Supreme Court, the great Chief Justice John Marshall, the great Chief Justice who really left us with at the beginning of the Republic with the first articulations of what the U.S. Constitution meant. In a very famous case, Marbury versus Madison, the great Chief Justice said, no provision of this Constitution should be rendered meaningless surplusage, meaning it's not our role as a Supreme Court to interpret something in a way that just wipes it out of existence. And fortunately, I'm sorry, Justice Landau, I'm going to throw another rock at the current U.S. Supreme Court. The U.S. Supreme Court seems well on its way with the insurrection clause to just simply interpret provisions of the Constitution that it doesn't like in ways that render them entirely meaningless, which is it will not redound to this current Supreme Court's historical standing. 100 years from now, I think law students will be thinking very unkindly, if they think at all, about this court.
And it wasn't an insurrection, it was a love fest.
Okay, once again, I want to thank all four of you for taking time out of your very busy schedules to share your wisdom on the 14th Amendment and on the state of our nation with all the rest of us today. And let's keep it up. Thank you very much.